Welcome back to Lost Test Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. In this video, we're going to revisit the question whether the Fourth Amendment, the one that protects you against unreasonable searches and seizures, protects you against a government search in a rental vehicle, one that you do not own. In this video, we'll be discussing United States versus Derek Daniels Jr., which is a Fourth Circuit case that was published just a few days ago on July 25th, 2022. Mr. Daniels had a number of outstanding warrants. The officers obtained a valid warrant to track Mr. Daniels using cell phone towers. Using that location data, they figured out that he was driving a gray Dodge Charger. Now, the officers, using the tags that were from Florida, figured out that the vehicle was a rented vehicle from the Enterprise, the rental company. Now, the following morning, the officers executed the arrest of Mr. Daniels outside a hotel room. And outside that hotel room, there was the Dodge Charger. While they were walking Mr. Daniels to the police vehicle, one of the officers asked Mr. Daniels if he knew anything about the rented vehicle, the Dodge Charger. Mr. Daniels replied that he had no idea anything about this Charger. So the officers set him in the vehicle and made the arrest. The officers then called the Enterprise risk manager to figure out what to do with the vehicle. The individual working for Enterprise told the officers that because the rental agreement did not list Mr. Daniels as the authorized user of the vehicle, they have a right to seize the vehicle and take it to their lot. So the Enterprise agent called a tow company to seize the vehicle. The officers followed that vehicle to the Enterprise lot, and there the officers asked the individuals working for Enterprise if they would consent to a search of the vehicle. Those people working for Enterprise consented. Now, the facts are not exactly clear whether they were consenting or whether the actual individuals working for Enterprise were making the search, but regardless how practically it happened, a gun was found in the front area of the vehicle under the floor mat. The officers called the scene investigating officers. They checked on the firearm, and Mr. Daniels' DNA was found on the firearm. Mr. Daniels was charged as felon in possession of a firearm under 922G. Now, I have a number of videos dealing with this statute, and in fact, I even have a video that discusses all gun laws in the United States, federal laws in the United States. Most of them are found in section 922. So I encourage you to go back and watch that video. It will give you a lot of information about 922G and the gun laws in the United States. So Mr. Daniels was charged with having a firearm. He then filed a motion saying that the search of the vehicle was illegal in violation of the Fourth Amendment. After all, the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they can go into your property, for example your vehicle, and search it. Of course, this channel goes over a number of exceptions. We have automobile exception, we have an exception dealing with inventory of items in the vehicle. I encourage you to go back and look at some of those examples, an exception to the Fourth Amendment requirement of a warrant. I have a whole series dealing with all of those exceptions, and I will link it above so you can watch that. But in this situation, the question is much simpler. The Fourth Amendment protects you only in the items that you own or you have a reasonable expectation of privacy. Remember the Supreme Court case Katz? That's the case that introduced us to the concept of expectation of privacy. And until 2018, we were not sure whether an individual would have reasonable expectation of privacy in a rented vehicle. In 2018, a Supreme Court case Byrd came out. I have a video on that Supreme Court case, and again, I will link it above so you can watch it. And the Supreme Court told us that an individual can in fact have a reasonable expectation of privacy in a rented vehicle even if he's not listed in the rental agreement, as long as his possession of the vehicle is lawful. In this case, the Fourth Circuit agreed with the lower court that Mr. Daniels did not provide any information that he in fact had a lawful possession of the vehicle. The rental agreement indicated that Erica Baldwin was the individual who was the authorized driver of this rented vehicle, of the Dodge Charger. And Mr. Daniels did not testify or provide any information during the suppression motion hearing saying that he was in fact lawfully in possession of this vehicle. And because he didn't provide that information, this circuit court agrees with the lower court, saying that the Fourth Amendment did not protect Mr. Daniels against the search by the police. And so they were correct in not suppressing the firearm and charging him with felon in possession of the firearm. What is the difference between this case and Byrd? Well, in Byrd, we do have information that another individual rented the vehicle and gave possessory interest and granted permission to that person, Mr. Byrd, to drive the vehicle. That's not what's happening here. So when we're dealing with rented vehicles, the question also always becomes whether you're a lawful possessor of the vehicle. If you enjoyed this video, if you learned a little bit more about the Fourth Amendment and how it applies to rented vehicles, I hope you click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.